Today I'm going to cover some other definitions of law. All this week we are doing in your workshop what is law. I've done already this with 3 workshop groups. Your definition. I don't want you to come here and give me Austin's or Hart's or Kelsen or whatever. I'd like you to have your own definition. Whether you are going to include values, moral, religion, whether you are going to include punishment, or whether you are not going to include. And the main thing to me is why you are making those kind of decisions. Yes? You are going to be professionals very soon, so I'd like you to be able to argue, make a claim, make a case, and support your argument with what? With sources. That's what I'm doing here today. If I have time, I'm going to use Socrates right at the end, if I have time, to ask you whether there is a gap or you want me to revise something, because next week I'm going to start with a sort of revision of all these classes, 3 to 4 classes with me, so you don't panic, because I'm not going to ask you any definition. Yes? In December I said this, I'm going to put on Moodle 3 or 4 different choices. You are meant to write an essay, and you will have time until February to write that essay on legal theory, or feminism, or gender issues, or discrimination. Yes? It will be very, very open. My question, I can tell you, and I'm writing the exam, will be whether law requires moral values. It's an open question, which means you'll have to write an essay, and you'll have to choose an example to defend your point. So you may decide to include values, you may not. You may use abortion, organ donation, euthanasia, blood transfusion, and so on. It will be your decision what kind of research. Is that clear? But in no case I'm going to ask you what is natural law. In no case I'm going to ask you what is positive law. Or what is Hart's definition on law. Is that clear? Yes? Because some people get stressed and not getting the whole vocabulary. I don't want you to learn all these definitions. I'd like you to be more precise when you write the essays. That's the only thing we are doing here with me. What is law? Last time we introduced normative systems. The broad definition for normative systems, any set of rules. Yeah? From football or cricket to playing chess, and the ones we are going to see here, law, morality, and religion. Yes? Any set, any group of rules. For whom? For us. For people. Yes? Then we are going to distinguish law and morality, mainly next workshop, workshop 3 it is. You are going to have the first long case we are going to read here in Law and Society. It's a fictional case. It's the case of people, explorers, that go into a cavern and get trapped. And they need to kill someone in order to survive. And they're going to eat that someone. That's the case next week. These people are going to, this is a fictional, it has happened, but this is fictional. We are going to have 5 judges having completely different views. For some judges, these people are going to be innocent or non-guilty. For some others, they are going to be guilty. Yes? And we are going to see everything from what is law to natural law positions. So some judges are going to use moral in order to make a decision. And we are going to use as well positive law. So we are going to apply everything next week in the workshops in terms of law and morality. And we distinguish mainly positive law as opposed to natural law. The difference being who makes the law, who creates the law. The distinction, if men as species, not as gender, men as species, men create the law, to men we talk about positive law theories. Yes? If anything else, God, nature, reason creates the law, we talk about natural law theories. Nothing else, it's very simple. Yes? So if I'm telling you Parliament has created an act, I think of positive law. Yes? If I'm telling you my law is the one from the Quran, or my law is the one from the 10 Commandments, God is, or Allah is creating that law, yes? Which means I am a natural law theorist. Am I clear? Yes? All natural law people will somehow include moral values. All. That's why when you read the case for next week, you are going to see first sentences. And you want to say, wait a second, this judge is a natural law, he's going to include somehow values. Yes, he is going to talk about right or wrong. Am I making sense? That is from last week. Remember, what is law? A set of rules. with or without moral values, with or without punishment. I started with one definition. I said I started because we didn't really go into this. We used to have in this country, and I'm going to show you only a few slides. I rather put all the presentations in your handouts. You get everything. You know, you have everything. I'm going to only give you the most important part. You know what you may need, nothing else. If you want to do your essay on option 1, legal theory, you have everything here, even the resources. Yes, you don't need all this for your workshops. Yes? That's why I'm not going to go through all the slides. However, I'd rather you have all the information. Yes? And I'm going to put on Moodle as well some other videos I made years ago about this as well. Extra information, you don't need that. Yes, but you cover more than everything you need. For this guy, Austin, he used to teach in Oxford. This is the classical example of Anglo-American understanding, the UK, the United States, of what is law. We have a sovereign, who is a superior in any territory, yes? Creating law, creating rules. Remember, law is a set of rules. He is obeyed by whom? By people in that territory, and he's not in the habit of obedience. Why? I put this example. I'm here, I know I'm not the superior authority here because I receive orders from my land manager, and he receives orders from the head of the department, and she receives orders from the head of the faculty, and so on. Yes? If we have something superior, someone or something superior, we are not the sovereign. Yes? Someone else is telling me what is law, what is not law. Yes? So for that definition, law is a set of rules created by a sovereign. A sovereign means the highest authority in a territory. Clear? Now, that authority, the sovereign is going to create commands, orders, yes? That will have one element, according to Austin, one element. This is the main element in this kind of definition. And we talk about this in my workshops. I can see some people here from my workshops. Sanction. Sanction. For this guy, for this guy, John Austin, sanction means harm, pain, or evil. The three typical examples of sanction are freedom, money, and life. You do something wrong, and I'm going to apply a fine. I'm going to put you in jail, so fine, money. I'm going to take you to jail, freedom, yes? Or I have to have death penalty, yes? So in those kind of cases, only for that guy, this set of rules created by someone, the sovereign, yes? Whether I talk about values or not, I don't really care. As long as I have a sanction, a punishment if you wish, a punishment, I have law. If I don't have punishment, if I don't have a sanction for this kind of definition, which is not the only one, yes, which is not the only one, but for this kind of definition, if I don't have punishment, I don't have law. If I don't have sanction, I don't have law. Yes? I may have a piece of advice, yes, wishful thinking. I may have moral standards, nothing else. Am I clear? Yes? If I don't have a sanction, I don't have law. Is that enough? No, it's not enough. That's wrong. Why? Because now we have Hart. After Hart, same chair in Oxford, after Austin, sorry, we have Hart, his student. Hart was John Austin's student. He's going to come up with his own theory. What we tend to see in law in general, but in jurisprudence probably it's more evident. We have someone, and then we are going to have someone after that will take some elements from the theory before and will try to improve. We'll criticize and we'll try to improve. This is an example. Yes? We had Austin first with a very classical definition of law. A set of rules created by someone, the sovereign, and in all cases we have to have punishment. Yes? After Austin we have Hart. Hart is going to tell us something different in this book here, the concept of law. There are some other publications. I'm going to only refer to this one. Concept of law. bracket here. I used to do this in a jurisprudence. This is not jurisprudence. At the University of Manchester, I used to take 6 classes only for this book. 6 classes. Some of them 2 hours long. Yes. So I'm going to do my best in 30 minutes to put basic information. Yes. I used to do more than 6 hours, probably 10 hours only on this book. Yes. So what I'm going to do, once again, if you're interested, I'm more than happy you send me an email, answer questions. If you want in the future to write an essay, more than happy. The only thing I'm going to do is just the common ground, the basics, so we know what we are talking about when we define the law according to him. Clear? But there is a lot more. Yes. I'm going to refer to, first we talk about Austin. The definition I was talking about comes from Austin. Yes, UK. This is continental Europe. I'm not going to refer to him. If I were to be, let's say, in Africa, Latin America, Asia, I will be talking about this, not about Hart. Yes? Because Kelsen and Austin used to see in a similar way the law. If we don't have a sanction, we don't have law. End of. That's the end of the story. Yes? Now I'm going to go here. Yes, we are going to talk, because that's how we see the law now in the UK, in America, in Australia, in many countries. But mainly Commonwealth countries, You know the difference between Roman style law and Commonwealth law? Yes, ex-British jurisdictions. Yes, we're going to go here now, the concept of law. And I put this on Instagram. Are you receiving my Instagrams? My Snapchat? Yes, do you find it okay? I'm trying to do my best to put 2 or 3 pictures, just to show you, because it can be very boring, yes.
Could you make them a bit longer, the timer? Otherwise it sometimes...
Perfect. Thank you very much. You tell me, because I'm learning to use Snapchat with you. I'm sorry if I've seen some of your pictures. That was my intention. Yeah. I'm learning to use Snapchat. The first 20 pages, it's true. The first 20 pages of this book, The Concept of Law, have to do with something very basic. The whole book is about your workshop this week. What is law? That's why the name, The Concept of Law. The whole book, 200 and odd pages, has to do with a definition of law. The first thing he's going to do, he's going to introduce us 3 different problems that we always find when we ask this question, what is law? Whether law is only an issue with coercion or related to coercion. Yes? So whether law, according to all up to Hart, law has to do with coercion. Remember I said that before, a set of rules by a sovereign, always with punishment. Yes. So up to here, always related to coercion. Yes. Somehow, for all up to Hart, I'm talking about 60s here, so it's not that long ago. Law and coercion somehow may have something to do with morality. Yes. And in all cases, law is defined by this concept, rules. He is going to have problems here. He's going to find problems. He's not discovering anything new. He's going to see something. And I'm going to refer to some of these points. He's going to see that there are legal rules that do not have coercion, and they are still law. There are some that are going to include morality when discussing law. There are some that are not going to. When I mean some, I mean parliament, I mean judges. Yes? And rules do not only define law as we know now. Rule is too broad. We may be talking about any normative system, even football. Yes? So although we seem to be talking about the same concept, we are talking about very different ideas. Yes? So what he's going to do, he's going to criticize all this.